of the Land Titles Clarification Act. It even amends the title, which gives you an indication that whatever the reason was for the original Land Titles Clarification Act, it's being changed. And indeed, when we look at this bill, we see that's exactly what's going on. Now, the Land Titles Clarification Act deals with a procedure for clarifying land titles in certain very defined and narrow circumstances that are laid out in this bill. In the Land Titles Clarification Act. And what this bill does is it leaves that alone, and it adds a whole new regime, a completely different purpose, a completely different method and procedure for releasing the Crown's interest in land. So they've taken a bill that had one very definite, narrow purpose, and they've essentially called that Part 1. And then they've added a Part 2, which has no relation at all to Part 1. So that's a second clue that something mysterious is going on here. Our third clue is the fact that the amendment that's being made starts by saying, notwithstanding Section 15 of the Crown Lands Act. Now, I went and picked up the Crown Lands Act and looked to see what Section 15 says. And what it says, in essence, is that the Minister of Natural Resources shall not give up the Crown's interest in land except in accordance with this Act. So suddenly, here in this bill, this so-called Justice Administration Act, we have a new provision that applies notwithstanding Section 15, which means that it's creating a whole new method for alienating Crown land. A whole new method, one that's never existed before, a whole new procedure for the Crown to give up its claim in certain Crown land. Now, Mr. Speaker, this may be a good thing. It may be a necessary thing, but I think the government owes it to the House to give us a great deal more explanation than it has already given, because we are suspicious. And there are lots of other environmental groups who are also suspicious because they've seen how the government deals behind closed doors with Crown land issues. So while I will say that it seems very likely that our caucus will support the bill on second reading, in principle, I don't want the government to get the message at all that this bill is going to receive clear sailing in future stages, because there are things here that need to be explained. Now, I suspect, as was pointed out last night in the very clear and thoughtful speech of my colleague from Halifax, Shabukto, that this may just be part of the fallout from the change that we've had in the land title system in Nova Scotia. This may be just one of the things that's come up and needs to be clarified. But if it is, Mr. Speaker, then this is a perfect example of the sledgehammer killing the fly. Okay, so we have a little bit of a problem where certain areas in the province need to have the Crown's interest in the land clarified. Well, that's fine. We could deal with that if the bill were tailored to achieve that purpose. But instead of that, we have the government creating a big exception, a new procedure that will exist forever for all Crown land anywhere in Nova Scotia. So if the purpose of this bill is to deal with some of the small problems that have arisen because of the change in the land registration system, well, let's deal with that. Let's tailor the bill to deal with that problem instead of creating this big exception to the Crown Lands Act and the Land Titles Clarification Act. That's not the only problem with the bill that I wanted to highlight, Mr. Speaker. And as I said, I know that in principle on second reading we're not supposed to talk about specific sections of the bill, but this is a challenge we have in omnibus bills, is there is no common thread. There is no common idea. This so-called Justice Administration Bill ranges over the Public Archives Act, the Vital Statistics Act, the Land Titles Clarification Act, the Land Registration Act, the Assessment Act. There is no common thread. The only common thread is they're slammed together in one bill. And the government shouldn't be doing this, and the Minister of Justice shouldn't be doing this either. These bills deserve to be treated separately and to go through this legislative process separately. So the other one that I want to talk about has nothing to do with land titles clarification, nothing at all to do with land titles clarification of Crown lands, and that is the amendments to the Vital Statistics Act. Now, what caught my eye here, Mr. Speaker, again, is the government giving itself an enormous new power. And it has to do with privacy and the rights of Nova Scotians to know what's being done with the information held in the Vital Statistics branch of the government, which holds a lot of important and very sensitive personal information about births, death, marriages, and all the details that go along with those. Well, what is the government doing here? Well, if we look at one of the amendments to the Vital Statistics Act, they are creating a huge exception to Nova Scotians' privacy rights. They are amending Section 35 of the Vital Statistics Act, and I'm going to read it because it's only by reading it, Mr. Speaker, that I think I can underline what the problem is that I see with this. It's going to add the following paragraph to the powers of the registrar. It says, so that the registrar shall, quote, evaluate requests for access to information from the office of the registrar, and where the registrar is satisfied that the request is not for an unlawful purpose, authorize the release in accordance with any conditions the registrar may prescribe, end of quote. So what that does is it says that if the registrar gets a request for information, as long as the registrar is satisfied that it's not going to be used for an unlawful purpose, then the information can be released. Well, it doesn't take a genius to figure out that the registrar is not going to approve the release of information for an unlawful purpose. None of us would approve that. But apparently, any other purpose is fair ball. It's just up to the judgment now of the registrar. In contrast to the regime we have today, which is the Freedom of Information and Protection of Privacy Act, which governs in great detail when private information can be released. The Vital Statistics Act is given as one of the exceptions to that act in Section 45, but again, Section 45 of the Vital Statistics Act probably says exactly what it should say, which is to impose quite severe constraints on when information can be released. So instead of this legal regime, which has existed for quite some time now in Nova Scotia, governing release of information from the Vital Statistics Branch, protecting Nova Scotians' privacy, we have the government in a so-called Justice Administration Act blowing an enormous hole in this regime and saying, well, whenever the registrar wants to, the registrar can release the information. Well, what's wrong with the existing regime? What is the problem the government is trying to solve? Why is it necessary to replace the regime of the Freedom of Information Protection and Privacy Act and Section 45 of the Vital Statistics Act with an overriding discretion of the registrar to do whatever the registrar pleases? And again, Mr. Speaker, we're suspicious because this government does not have a great track record on freedom of information and protection of privacy. And if I ever thought my concerns about the government's stance would be allayed, well, all I have to do is pick up today's paper, and I know that we should be worried all over again. There's an article in today's Halifax Chronicle-Herald on page B5 of the Metro edition where a well-known advocate of freedom of information is asking the government to reduce the fees for freedom of information. And the minister's answer to this, and I sincerely hope the minister was misquoted on this. I sincerely hope he was, or that it was taken out of context or something. Here's what the minister says. Quote, I would like to see us ensure that we have a fair process for people to get the information from government.
To question whether something that's written in the local paper is correct or not.
No, that's a matter of opinion. I will allow the member from Halifax Fairview to continue.
Thank you, Mr. Speaker, because of course I'm just going to read what's printed in the paper, and the minister can pass his own judgments about whether it was correct to quote. I guess my point is I sincerely hope he was misquoted because of what he's saying. Okay, so, so the quote is this. I would like to see us ensure we have a fair process for people to get the information from government that they think they should have.
Order, please. The Honourable the Minister of Justice.
It's very inappropriate to allow a member to stand in this House and read the daily paper. We all subscribe to the daily paper. You can read it at our own leisure, but to allow him to stand here and read verbatim a whole article, when does it end, Mr. Speaker? And again, I question the rules of this House for allowing the reading of a newspaper and to question whether an article in the newspaper is true or not.
Okay. I agree with the Minister of Justice. I'll ask the Honourable Member for Halifax Atlantic to continue his debate on the bill, please, and not make reference to his newspaper article.
Thank you, Mr. Speaker. So is it now the rule of the House that one cannot quote from a newspaper? And even a single sentence from the newspaper? It's now against the rules of this House to quote a single sentence from a newspaper? Is that your ruling, Mr. Speaker?
I would ask the Honourable Member to continue with his debate, and if he wants to make reference to his newspaper, then I would ask the Honourable Member to table his newspaper. That has been a precedent in this House, and I certainly see no problem with that to continue. But again, I think the Honourable Minister of Justice makes a very good, valid point that it's not the interest of this House to read the paper for the record.
Mr. Speaker, I do understand why the minister might be a little bit loath to have this sentence read in the House. And for the third time, Mr. Speaker, I'm just going to try and relate a single sentence from the newspaper. And it's a bit of a shock to me, the idea that it is now against the rules of the House to quote a single sentence from a local Nova Scotia newspaper. That's fairly new. The gist of what the minister is trying to say is that he thinks we should have a system, Mr. Speaker, where the information that gets released is in accordance with what the government thinks should be released. That's what he says. That's what the minister says. That's what the minister actually says, is that it's okay to change the Freedom of Information rules as long as the information that is released, is in accordance with what the government wants to be released. Now, when we have the Minister of Justice, who's in charge of the Freedom of Information Protection and Privacy Act, saying that kind of thing in a local newspaper, Mr. Speaker, well, it's no wonder that we have cause to worry in this House about where the government's going with freedom of information and protection of privacy. Now, and so that brings me back, of course, to the bill that's before us, where the government is blowing an enormous hole in the regime governing the privacy interests of Nova Scotians dealing with the Vital Statistics Branch. And so instead of following the regime in the Freedom of Information and Protection of Privacy Act, or even the more limited regime in Section 45 of the Vital Statistics Act, they're saying, well, let the registrar decide when the information is going to be released. It's up to the registrar. Well, why do we need this? Maybe there's a legitimate reason. Maybe there's a particular case that's come to the attention of the government where they felt the existing regime was too restrictive. But let's deal with that. Let's hear what it is. Let's have the minister stand up and say, here is what we were trying to address, and then explain why, to deal with particular instances that may have come to the registrar's attention, we need this sledgehammer which says that always, for all time, in every case, for every bit of information the Vital Statistics Branch holds, it's up to the discretion of the registrar. So, Mr. Speaker, as I said, when this bill comes to for a vote on second reading, it will pass second reading, because it should. But I don't want the government to think that just because it passes second reading that it's going to get smooth sailing. The government owes it to this House not to keep introducing these omnibus bills with provisions that have nothing to do with each other. If the government has things it wants to accomplish, let it introduce separate bills so that the principles of the bills can be debated in the way that the rules of this House meant them to be debated. Not a bunch of unrelated provisions thrown together to be debated once as if they had anything to do with each other in one bill. For once, let a minister of the Crown stand up and give a proper second reading speech saying, this is the philosophy of the bill. This is what we're trying to accomplish. This is why we chose this particular method of trying to accomplish it, so that there is a record for all time in the House about the government's thinking behind the bill. We lack those things on this bill, Mr. Speaker, and without those things, it is simply not possible for this House or this caucus to say that, that we will support it through every stage of the House. Thank you, Mr. Speaker.
Are there further speakers before the Chair recognizes the Minister of Justice to close debate? The Honourable, the Minister of Justice.
Thank you, Mr. Speaker, and thank the honourable members opposite for their comments and I'm sure discussion, and as well suggestions they made will be considered by ministers responsible for those various sections. Mr. Speaker, I would like to point out that last night in this House, a member opposite for Cole Harbour Eastern Passage pointed out on at least a couple occasions that that this bill before the House was insignificant. And Mr. Speaker, I think that's totally wrong. I think it's very unfortunate to have comments like that made in the House. For example, Mr. Speaker, part of this legislation before the House talks about the Public Archives Act. And that's a piece of legislation, Mr. Speaker, that millions of pieces of information that Nova Scotians are waiting to access. And I say, Mr. Speaker, those who are involved in genealogy, and maybe members opposite think that those types of things are insignificant and don't mean a lot, and that the bill before the House is insignificant. But, Mr. Speaker, well, that was the comments of the member opposite, Reed Hansard, said this was an insignificant bill. So that's not insignificant. Nova Scotians are waiting for this. Millions of pieces of information to be made available to Nova Scotians, those involved in genealogy, very important to them, and that's a good indication, Mr. Speaker, how important this bill is before the House. But again, Mr. Speaker, look forward to this bill being passed to law amendments. And with that, Mr. Speaker, I move second reading of Bill number 21, Justice Administration Amendment 2006 Act.
Thank you. The motion before the House is for second reading on Bill number 21. All those in favour of the motion, please say aye. Aye. Those against, motion carried.
21, entitled An Act Respecting the Administration of Justice.
Ordered that this bill be referred to the Committee on Law Amendments. The Honourable, the Deputy Government House Leader.
Thank you, Mr. Speaker. Would you please call Bill 23, Wills Act, for second reading?
Bill number 23 for second reading. The Honourable, the Minister of Justice.
Thank you, Mr. Speaker. And again, Mr. Speaker, it's a privilege to rise and to speak on Bill number 23, the Wills Act. Mr. Speaker, the Wills Act is being amended to update the Act and bring it more in line with other Canadian jurisdictions. These amendments, Mr. Speaker, clarify the effect divorces have on wills. In fact, the amendments also clarify the distribution of property located in Nova Scotia under wills made outside of this province. I'm pleased that the Act will also permit handwritten wills, Mr. Speaker, something that's probably long overdue and I think will be welcomed by many Nova Scotians. This will make preparing a will easier and less costly for Nova Scotians who face challenges in regards to funds. Mr. Speaker, these amendments respond to recommendations of the Law Reform Commission and will make it easier for people to ensure their final wishes are fulfilled here in Nova Scotia. Mr. Speaker, there was a significant amount of public consultation on these amendments, and I'm very pleased to bring them forward this time. With those very few comments, Mr. Speaker, I move second reading of Bill number 23, the Wills Act.
Thank you. The Honourable, the Member for Cole Harbour Eastern Passage.
Thank you, Mr. Speaker. I'm glad to have a few minutes to speak on the Wills Act. This is a bill that I think is one that I know that I believe the Law Reform Commission had done a lot of work with regard to this legislation, and I think some of this bill is reflected in the work that the Law Reform Commission has done. If not, then I would still like to applaud the Law Reform Commission for the work they do, and particularly in the area of estates and wills and probate. They've done a lot of good work in the last few years, I know, to try and enhance and modernize our system. I believe this bill does have some of the provisions that they've recommended in it, and I applaud that as well. And obviously, anything that makes the process of wills and how we can make the writing of wills and the adoption of wills better, I think is good for Nova Scotians. I guess I do want to take an opportunity to talk on the principle about a particular issue that I've heard from people in my constituency about, which is something called a wills registry. And I sort of throw it out there. Maybe some of the other members of the House may have some thoughts on this. But like we have a land registry for deeds, where mortgages and deeds have to be filed with a registry, an individual has come to me and suggested that maybe we need the same thing for wills, if not mandatory, at least voluntary. Because one of the problems that can arise with a will is that if someone passes away and no one knows where the will is, and no one can find the will, and no one can prove that the will, sort of the consistency that this is the will that had been signed by the individual, then the person becomes intestate, meaning there is no will, which means you have to go to court, you have to go through a very long and protracted process with administrators. And Mr. Speaker, this person has suggested, at least on a voluntary basis, we should look at a registry, if not the actual will itself, as a minimum, at least the location of a will, so that people can, if someone passes away, go to a location, either government run or government sanctioned, that would then have a identification of an individual. If they pass away, you can go check date of birth, name, location of where they were, and where the will is located. So I think that this, and that might be the case, it might be under the mattress, but at least then we know where it is. So I actually think that that's not a bad idea. Now, I'm not one who's, when I practice law, practice wills and estates. So it's not an area that I have a lot of expertise in. But I would say that it is something that we should look at as a possibility, and I know the Minister of Justice's staff has met with this individual, particularly on this issue, and I appreciate them doing that. But I do believe that this is something that's worth considering. I think that it would go a long way to ensuring people who have written a will, and for whatever reason, maybe the lawyer passed away, was the sole proprietor, maybe maybe the firm broke up, maybe they were the holders of the will, maybe the individual held it somewhere. If we could identify a location where that will is located, or otherwise, alternatively, have the will stored in a specific depository, I think it would go a long way to ensuring that people would have a sense of security, that when they write a will, that will is going to be located in a certain location. And then, of course, the whole other issues of, is it the most recent will, and the other things would come into play. But my suggestion is this. I think it's worth the government study. I'd like to see this bill begin the process of at least looking at that as an option. I think it's a good idea. It's one that I think can ensure that many people in this province do not have to face probate court, don't have to face being intestate, and can actually see an opportunity for the will to actually make what they intended is what will be in place, because they have a place, either themselves or the lawyer will be able to store the will, or at least have a depository that identifies the location of the will. And I think that's not a bad idea. And I've been loath to find anyone so far who has thought it was a bad idea. I'm open to comment from others, both in this House and outside, who may be listening or may read Hansard, who may have comments on this. I'll be looking forward to law amendments to hear from people on this very issue. But I think it's an interesting one, and I think it's worth considering, because I think people of Nova Scotia would then be better off. I do know they have similar legislation in British Columbia as well, Mr. Speaker. I believe there it is a depository for the location, or it's a voluntary depository of wills. But at least there is something in place that allows people, if they want to go that way, to have it. I think it's a good idea. It's one that I'd like to see developed, at least considered, at least studied. I'm prepared to accept that this may take time, but I would like to see it put in place so that the people of Nova Scotia do have that option. And it's one that I don't think would cost the government money necessarily. It could be done through license and permits of individuals who are provided with that, especially if it's a voluntary one. But I would encourage the government to think about that. It's something I'm going to raise at law amendments. I'm going to raise with my caucus, and I would hope it's an opportunity to consider advancing this idea. And I know it came up through the Law Reform Commission as well, and it was something that they considered as well. So, having said that, we will see this bill. We don't have a problem with this bill going forward. We'll listen to law amendments to see if there are any comments. It's an area of the law that I think there are people who are experts who specialize in this may come forward with their comments. I'll be glad to hear from them. There are obviously stakeholders that may have their concerns as well. But in the long run, I think anything we can do to improve and enhance wills in this province is a good thing. It helps ensure that when people pass away, that their intentions of the division of their property are clear and are protected. That is an area of the law that we've had for centuries, and it's one that we need to maintain in an era in which electronic media is becoming more common, and I think it's one that I'm glad to see the changes that we're making here today. Thank you.
The Honourable, the Leader of the Liberal Party.
Thank you, Mr. Speaker. As Justice Critic for our caucus, it's a pleasure to rise and speak briefly on Bill number 23, Amendments to the Wills Act. And certainly, Mr. Speaker, allow me to take my opportunity to once again commend the Law Reform Commission for the excellent work they do. And I would take this opportunity to remind the Minister of Justice that as the budgetary process will inevitably begin up in the upcoming spring, that I would hope the Minister of Justice will be a strong advocate for the Law Reform Commission to make sure that they do have the adequate financing and possibly new financing to help them in some of the work they do. And I'm certainly pleased to see that the Minister, much like his predecessor, has been listening closely to the Law Reform Commission and adopting many of their changes in updating legislation here in Nova Scotia. There's no doubt that the Wills Act was in need of some updating, and the proposals here, I believe, will make for stronger legislation and will make it easier for Nova Scotians to be able to make clear what their final wishes are. So, Speaker, I also, much like the House Leader for the NDP, take this opportunity to encourage the Minister of Justice and the government. And I know that the legal community has done a lot of work to try to educate Nova Scotians about the need for them to make their final wishes known and to have proper wills. And there's a question of, is there something that we can do through the Department of Justice or through government, through the government's means of communicating with Nova Scotians, to encourage Nova Scotians to get wills, not simply to help lawyers have more business, but to make sure that Nova Scotians fully understand what the consequences are when you die intestate, that you have not made it clear what your final wishes are, the cost that there is to your estate, the cost of going through probate, the taxes that are involved, and the overall grief that it causes to those left behind at such a difficult time. And as I mentioned, I know in the Strait area, a lot of lawyers will meet with seniors groups, will meet with different groups and try to educate them on the need to have wills and the importance of it. And I would hope that the Department of Justice would look at that as well. Mr. Speaker, one of the other issues that I would encourage the Minister of Justice through his department to look at as well is the explosion of these homemade will kits that have been provided in our province. Now, Mr. Speaker, I've had the occasion in my legal capacity to see a number of clients who've come in and have shown me these homemade wills that they had from these kits. And I can tell you that from the ones I've seen, I don't believe one of them would stand up in court. And it's unfortunate that Nova Scotians are being led to believe that by buying this book for a cheap price and avoiding going through getting the expert opinion of a lawyer, that they're writing these wills that somehow they're believing they've managed to save some dollars on, and they've made it clear what their wishes are, because you can drive a truck through these homemade wills. And the fact is that your first year of law school and learning about wills in the States, or your second year, I guess, is when they teach you wills in the States, is that all of the ABC rules of drafting and of executing a will are void in these home will kits that you're seeing. And I find it very unfortunate. In my case, fortunately, they did come with me and show me these wills, and I was able to give them an opinion that I didn't believe it was worth very much as compared to what the end product they received after going and getting an actual lawyer to draft up their final wishes for them. So I think it's a question which I don't know if the Department of Justice has ever turned their minds to, especially the fact that each jurisdiction in Nova Scotia has some different peculiar rules that they have for wills, and I'm not sure if these homemade kits are making it clear to individuals here in Nova Scotia about specific rules that may apply here, and whether it's something the Department of Justice may want to look into and at least get a sense as to whether Nova Scotians are receiving the proper instructions in these home will kits, because it would be terribly unfortunate for any Nova Scotian to have written getting their will done through these home will kits under the belief that their final wishes are clear, only to see their family left behind fighting in court because of the fact that the will was not clear, was not properly executed, and is not therefore valid in our province. So those are some of the concerns that I raise with the Minister. Again, one of the other suggestions I make to you, Minister, and through your department, there are still a tremendous amount of families in Nova Scotia where the couples only have their deed and the car registration, any other lands they own, in the husband's name. And that was the old style, and that's how it happened. But now what happens is that we've seen a number of cases in our communities where when the husband passes away, everything was in their name. And so even though there's a will, in most cases they're being forced to have to go through probate and facing the extra cost of going through probate because of the fact it wasn't joint tenancies on either the land zone, the home, or even vehicles, for example. So if there's even a way that the Department of Justice could have a public campaign, because for most cases now, Mr. Speaker, this is more of a problem with older couples, because for the most part now, any couple today purchasing a piece of land would automatically get a joint tenancy for the most part. But I still see a number of seniors. I had a couple come in just last week to my office asking whether they should be concerned about the fact everything was only in the husband's name. And I made it clear to them that yes, it was a concern. It would create headaches down the road if it wasn't addressed, and they're taking corrective action now. But there's still a tremendous amount of families that aren't familiar that this could create problems for them in the future, and that it can easily be avoided by simply changing that to joint tenancies rather than leaving it only in the name of one spouse. So I leave that with the minister. I'm not sure if there's a practical way that the department can undertake this kind of information campaign, but I think it's something that we want to make sure that Nova Scotians are fully aware of how they can make sure that their final wishes are clear, that they're not going to have to face probate if it can be avoided, and more important to most Nova Scotians is that they're not going to have to pay the government any more taxes than necessary on their estates. So, which I'm sure the Minister of Justice would be very concerned to protect Nova Scotians in that regard as well. So with that, Mr. Speaker, we certainly look forward to this bill moving forward, and I can say that despite some of the criticisms the Minister may have faced last night about the value of some of the legislation, I do believe that these changes will certainly have a significant impact on our province, especially for those who have wills and who will be the families that will be relying upon the proper interpretation of those wills in the future. So I commend the Minister and look forward to second reading on Bill number 23. Thank you, Mr. Speaker.
Thank you. Now recognize the honourable member from Hanseas.
Thank you, Mr. Speaker. I'll be brief on this in my comments on this bill. I have to say that unfortunately, even though I would be the equivalent of a clone, being an identical twin, my brother, who is a lawyer, there's no way to transfer your legal training to your twin brother, and yeah. Didn't keep the political smarts, but I want to say that when it comes to looking at this piece of legislation, it's I come at it from a layman's perspective, and in reading sections of the Law Reform Commission report, actually that was fairly enlightening. And I'm glad to see that the government did look at that report when they drafted this legislation. And I have to agree with the minister that I would certainly see it as an improvement in the accepting of a handwritten will. And I think that for all Nova Scotians, and certainly those who are not connected to a legal profession or don't have a legal background, all they really want is the ability to convey their last wishes in regards to their property and how they want that disposed of, at their death, and to ensure that this is done in as nice a manner as possible. Depending on family or how large or how, if it's to one individual, that's pretty simple. But if it's to more than one, they certainly want that their wishes are clear and can be carried out in a fairly forthright manner. So I think for all of us that would be where we would want to go. And I think the change that they made in terms of service people with the wording of changing actual military service to active service is an appropriate one. As much as people plan, sometime you do drop the ball, and people can be in another country, for example, certainly service personnel, and they would be on active service even though they wouldn't be in actual military service, and so to allow some leeway in that regard. So as I wind up my comments, Mr. Speaker, I do have to say that when the minister gets up to finish debate, or any of the other members of the House, But in looking at number 5 of the Act, as regards the manner and formalities of making a will made either within or without the province is valid and admissible to probate if it is made in accordance with the law in force at the time of its making in the place where A, the law of Nova Scotia, B, the will was made and the testator was domiciled or had his or her habitual residence when the will was made. And I got to say, I don't understand that. And I asked for some clarification on it and didn't get it. I didn't get it from the minister because I didn't ask the minister. But certainly I did ask for a legal opinion, and that doesn't make sense to me. And I don't know whether it's just in the wording because the person who I asked had difficulty saying that doesn't make sense to me. So. Anyway, I see this as an improvement, and certainly look forward to seeing it move through the House. And with that, Mr. Speaker, I'll let someone else have the floor.
Thank you. Chair now recognizes the honourable member for Halifax Clayton Park.
Thank you very much, Mr. Speaker. And I just wanted to have a few comments on this bill, which is Bill number 23, the Wills Act amended. Again, we do think this is an area that needed attention, and we're glad to see that the government is turning their attention towards that and trying to clarify some of the issues around wills. One of the things that I wanted to ask about, there are a couple of things I think that may cause some confusion. Section 15, which is referred to, I think, in the Act, the Section 5 refers to Section 15. But in that section, it refers to a will being valid if it's made in accordance with the law in force at the time of its making in the place basically where it's made. There's 4 points under that. And I'm just wondering if that won't be difficult for Nova Scotian courts to determine if wills are made all over the world. It's going to create a little bit of difficulty, I think, in terms of interpreting the validity of those wills. If they come from many, I'm sure within Canada it won't be a problem if it's other provinces, but I'm just thinking if we're accepting them from all over, and it does say if that's the place where you've been living, if that's your habitual residence, so it could be anywhere. As we know, we live in a very mobile society. People are traveling, and Nova Scotians are traveling all over the world for work and for living, and therefore I just suggest that there might be a little difficulty in that, requiring that the courts have extra knowledge to determine if it is a valid will in all countries. So that's one small concern. I'm also interested, the way I have read this is that in effect, the will is considered valid if it's in a person's own handwriting and if it is signed by that person. It seems to indicate there's no requirement for witnesses in looking at a will, and that I think might be problematic if we're talking about the need to protect some people, and I'm thinking there of people who might be elderly or infirm, and if there's been any pressure on them in preparing a will, there's no need for an independent witness. So you might find that somebody could be taken advantage of for that reason. So I hope that that will be something that is being considered. I do understand, that there's a need or an interest in simplifying the process and acknowledging people's wishes, but I'm just looking at the need, Mr. Speaker, to protect those that might not be fully able to control what is being written, or they might be under some undue influence of someone else. So that's very important, I believe. And I'm just looking, I think those are the main things we see. Oh, there's one point in here that also deals with divorce, which I wanted to touch on, and divorce and separation. And it says that the divorce has the effect of revoking a bequest or an appointment under the will. And I do think that that's a good thing to see in place, and I'm glad that that's been addressed, because it's quite possible that you might have a will in effect and not have that recognized that your marital status has changed and that those wishes might not, I think it would be certain they should be reconsidered again after a divorce or separation. So I'm glad to see that in there. I think it protects all parties as well. So thank you very much, Mr. Speaker, and I'll take my seat. Thanks.
Thank you. The Honourable, the member for Halifax-Shubucto.
Well, thank you, Mr. Speaker. We seem to have found ourselves engaged in a discussion of the inevitables, life's inevitables and unavoidables, both death and taxes, it's important, I think, that we maybe move to correct a small item that's found its way onto the record today. It had to do with the suggestion that the amounts charged for probate are taxes. I think, of course, since the decision of the Supreme Court of Canada in re Yorig's estate and the corrective measures this legislature took afterwards, we're talking about fees, not taxes. And of course, in Canada, we don't have any inheritance or taxes or death duties. So it's just fees that we're talking about for probate, and one can argue about the extent of them, but they're not taxes. I think we've taken the corrective measures and appropriate measures earlier on to eliminate that challenge here. That said, I have to say that it seems to me that when we engage in altering the law for a subject that is as old as the law surrounding testamentary devises, that we have to be very careful. And I must say that I think that the government has been careful here, because they consulted with the Law Reform Commission of Nova Scotia before they took steps to introduce Bill 23. The bill that we have in front of us is the result of a study commissioned by the Law Reform Commission. It followed appropriate steps of putting out a draft paper for review by the interested community, and then followed up with a final report from November of 2003. I could wonder why it's taken us 3 years to move on their recommendations, but I'm happy to put it down to caution on the part of the government. Caution and careful thought, let us hope. But that said, I think the government really has taken what were the core recommendations of the Commission at the time and has put them into appropriate language before us now as a bill. And the government did not attempt to implement any measures which the Law Reform Commission recommended against. Understandably, there are a variety of suggestions that are made from time to time for changing the law in this area or that area, and some ideas had been put forward. For example, the possibility of an electronic form for the writing of wills, and the Law Reform Commission suggested there was no particular reason to move on that, and this bill doesn't attempt to do so. I think what this bill does is it sensibly accepts the policy directions of the Law Reform Commission on what are known as holograph wills. That's simply a will that's in a person's handwriting. In doing so, we shouldn't assume that such wills would automatically be found to be valid by a reviewing court. Circumstances surrounding the writing of a will, whether holograph under our new proposed bill or not, are always up to be examined. A subsequent court could always make a determination that a person didn't have the testamentary capacity, they did not have the correct and appropriate mental ability to execute a will. That is something a court could always find, and indeed will still be able to find based on appropriate evidence in the case of a holograph will. A court can also set aside wills in circumstances of duress or undue influence, or if not the wills as a whole, certain bequests under them. I see no difference when it comes to a holograph will. All we've done here, those remedies will still be available. All we've done here is we have offered the opportunity to people who are sometimes in circumstances where it makes sense for them to write out their will by themselves in their own handwriting and sign it. And indeed, as the member for Clayton Park pointed out, it doesn't call for witnesses. It's meant to deal, this amendment is meant to deal with circumstances where people find themselves alone, where they might be ill, there might be an urgency. Sometimes they even apply to people who are in areas of particular danger for other reasons. So it's an appropriate kind of amendment to make. It's been a long time coming. I have no problem with this at all, but we should recognize that some of the traditional safeguards are still in place to deal with the kinds of circumstances that were identified by some of the previous speakers. I think it's also appropriate that we change the language to refer to active service for people in the military. This was recommended by the Law Reform Commission and reflects language that is in federal legislation that has to do with the nature of military service. So there's nothing wrong with that. When it comes to the issue of recognizing testamentary devices executed elsewhere, again, this is an appropriate thing to do. We are, as has been observed, a very mobile society now. People do move around the world. I don't want to be misunderstood. It seems to me that it makes sense for people to, if they move to Nova Scotia and are having some attachment here, which usually means ownership of property, then they probably should have wills made here and consult professional advisors. That would be the best thing to do. And I'm certainly not recommending holograph wills that people simply make up on their own. I think the thing to do, the better thing to do, is to consult a professional advisor about the wording. It may be that a will in holograph form is going to be valid, but it may be ambiguous. It may be hard to interpret. And the whole point about a professional advisor is that they can try to minimize or avoid completely circumstances in which those left behind to put into effect the wishes of the testator are puzzled by what they ought to do. So even though we're setting up the framework for recognition of foreign wills, and even though we're setting up the framework for recognition of the validity of holograph wills, it's certainly the case that people should consult those whose profession it is to draft testamentary devices. That certainly makes sense. At the same time, I don't think we should be worried about the court's ability to interpret what the law might be in another jurisdiction. There is a whole area of law known as conflict of laws that deals with questions of how we interpret the laws of other jurisdictions. And just to reassure the member who brought this up, I should point out that it usually requires the expert evidence of someone who knows what the law was in that foreign jurisdiction. So I think we can expect courts to be careful about that. That brings me now to the issue of the effect of divorce or a declaration of nullity on a will. It seems to me that the bill follows very closely what it is that the Law Reform Commission has suggested. We know that not only are we in a mobile society, we're in a society in which many marriages simply do not survive for a full lifetime. And the hard reality of that is that this does bring a change to people's lives. It does bring a change to how it is that they carry on their financial affairs. If a person dies entirely without a will, then we have a framework in place under what's known as intestate succession laws in which public policy says how property should be divided amongst survivors. Now what we've done is we've gone a little further and we've looked at the circumstances of divorce or a decree of nullity and suggesting that that should invalidate the provisions that refer to the former spouse. In the normal course of events, people who are getting divorced or seeking decrees of nullity will be represented by legal counsel. And I don't doubt for a moment that those legal counsel will advise the parties that they should acquire new wills. And I don't doubt that many people who are so advised will do that. On the other hand, some people will put it off, and there will often be a gap, sometimes a long gap, between the time of the divorce and the time a person gets around to doing, to having a new will drawn. What this clause deals with is the circumstance in which someone either neglects to have a new will done at the very time of a divorce, or unfortunately dies before they get the chance to do it. It's only right that we have such a provision. It's only right that this circumstance be addressed, and the minister has chosen to follow the advice of the Commission to essentially nullify the provisions that would benefit the former spouse. I think that's the right choice. I have no criticism to make of that. If a person decides that they wish to benefit a former spouse, they can put it in a new will if they wish. It seems to me that on all scores, this bill engages entirely appropriately with a complicated area of the law. There's I think, not much I can see when I look at what it is that the bill does that I can think of to criticize. I hope that if there's further detailed advice from the concerned professional community, that we do hear of it before we move on to third reading. But at this stage, at second reading, I have to say that I'm entirely happy to support this bill. Thank you very much, Mr. Speaker.
The Chair will now recognize the Honourable the Minister of Justice to close debate on this bill.
Thank you, Mr. Speaker, and I'd like to thank the members opposite for their comments and suggestions, and I will commit to ensuring that the department, thank you, ensuring the department and the staff review those concerns brought forward by the members opposite. Obviously, while we want to ensure that Nova Scotians have an opportunity to be able to afford to prepare wills and their last wills in this life, that we want to ensure as well that they will stand the test of time if the fact comes to that. So I think some comments have been brought forward here today. There's some very good suggestions, and we'll certainly follow up on that. And again, to the Law Reform Commission, we certainly appreciate the hard work they've done not only in this bill but in many other pieces of legislation that come before this House. So thank the members for recognizing that as well. So, Mr. Speaker, on that, it gives me great privilege to move forward for second reading Bill number 23, the Wills Act.
Thank you. The motion before the House is for second reading on Bill number 23. All those in favour of the motion, please say aye. Aye. Those against, motion carried.
Bill 23, entitled An Act to Amend Chapter 505 of the Revised Statutes 1989, the Wills Act.
Order that this bill be referred to the Committee on Law Amendments. The Honourable the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, would you please call Bill 14, Public Service Act, for second reading?
Bill number 14 for second reading. The Honourable the Minister of Service, Nova Scotia and Municipal Relations.
On behalf of my colleague, the Minister of Justice, I'm pleased to move second reading of the Public Service Act, Bill number 14.
Thank you. The Honourable the Member for Hanseath.
Thank you, Mr. Speaker, and I'll be brief. I'm not going to speak to all the parts on the bill. If my colleagues and their related critic areas wish to do that, that's fine. I want the government members to know I don't really have a problem with what I see here. I'm sure it would come under the housekeeping heading for the government. And in terms of the Department of Agriculture and the impact of this, I was certainly, and I should say Agriculture and Fisheries, I don't have a problem with what appears to be, and the minister may want to stand and correct me, but it appears to be a separation of agriculture and fisheries. And I know the agricultural sector certainly had been pushing for a standalone department. and that's the way I read this. And if I'm wrong, the minister can correct me. I do have a concern around Department of Fisheries, which looks to me like it becomes the Office of Fisheries and Aquaculture. And I want to mention to the Minister of Fisheries that this may be a tough sell. I think that the industry is big enough. Its contribution to the economy is plenty big. I think over $1 billion, and that's really in out of the water sales, if I understand it. I mean, that's the value of fish, and I think that's without much value added. I mean, that's just the value of fish coming out of the water around Nova Scotia, and $1 billion is significant, and very significant. And I think that that industry should be saying they want a department, not just an Office of Fisheries and Aquaculture, but they would want a Department of Fisheries and Aquaculture. And although that office will be supervised and basically overseen by the minister, I think we would recognize the department as having more clout than the office. And so that would be my only regret, I think, in how I read this. If the minister wants to correct me and say I'm wrong in my interpretation, I'd be glad to hear him say that. As a matter of fact, I'd welcome it. So I do have some reservations on what this means for fisheries. As far as agriculture, I don't see a problem with that. And if the minister, and I think the industry, and if the minister feels that would help him do his job, then I applaud it. So with those comments, I look forward to this bill moving forward, and I am eager to hear what other members have to say.
Thank you. The honourable member for Digby Annapolis.
Thank you. Thank you, Mr. Speaker. I haven't got much room here. Get your sea legs under you. We need room. Yeah, I'm pleased too, Mr. Speaker, to speak on this bill, Bill number 14, an act to amend Chapter 376 of the Revised Status of 1989, the Public Service Act. I too will just speak on the fisheries part of it, Department of Fisheries of this province. This bill, what it does, I guess, it amends the Public Service Act to divorce the Department of Fisheries away from the Department of Agriculture and create an Office of Fisheries and Aquaculture instead. So, and I would hope, Mr. Speaker, I would hope that this is not downgrading the Department of Fisheries for this province. This province has one of the best fisheries of this country, maybe more so a few years back. The fishery was a little better than it is today, but dollar-wise, it's still worth a lot of money for this province. The fishing industry sector has roughly doubled its contribution to Nova Scotia economy since 1996. And that's according to the new study from the provincial and federal governments of this country. The fishing industry in the ocean sector ranks second in the gross domestic product of impact for this province. The importance of this fishing industry to Nova Scotia is clear, and it leads all other ocean-related sectors in employment. So we can certainly see that it's important for this province, and we can certainly see that it's going to stay important for this province. There's nothing wrong with our fishery. I believe probably the government gets a lot of hearsay. Well, the fishery's no good now. Let's downgrade it a little. Let's look at downgrading. Well, I got people all around the coastal communities of this Nova Scotia saying to me, Mr. Terrio, we should have the Department of Fisheries and Oceans in this province, not sitting in Ottawa with thousands of people up through a 15-story tall glass building that we don't know what they do up there to this day. If it was in this province and one in British Columbia, I'm sure that things would work much better. And I hear that quite a lot. So here we are talking about downgrading the Department of Fisheries in this province, yet around the coastal communities you have people telling you to bring the Department of Fisheries and Oceans to this coast. And so that kind of bothers me a lot, you know, because I've always said that too. There's nothing wrong with our fishery. The only thing wrong with our fishery, when you depend on one species in the ocean, you do run into problems. The 50-some hundred boats around this coast that are diversified to catch many different species have no problem of surviving at all. And there's even more species coming on out there that we certainly got to work at. And I won't use the S word today. I'll save that for another day. But that's coming on. And Mr. Minister, we got to look at that seriously. The S word. Four-letter S word. That anyway, I won't go on too much. I mean, I just want to make sure that I get my word in here and say that this province's backbone, part of the major part of the backbone of this province is the fishery, was the fishery, and I believe always will be the fishery. Our shell fishery alone in this province is worth nearly $1 billion per year, just one species. The groundfish species, which is down now, still counts for 11% of that. So, and we got another species out there that may count for another huge percentage here before long. So that needs to be promoted and worked at. And anyway, but in closing, I just want to say, you know, that the strength of our coastal communities is in our fishery. And we cannot jeopardize that by downgrading this department. I hope this department is looking, when it downgrades, to an office that it has substantial and sufficient staff to do the work that needs to be done. And I also hope that somewhere in the wording in this bill that there is openings there for additional ways to put more staffing in if needed, if it is downgraded, the staff is downgraded from this office to be. So I would like to get that mentioned, and I would also, when this goes through law amendments, I would certainly make sure that that was worded that way. We got to be very careful, very, very careful with this great industry of this province. It built this province, and it'll continue on to keep this province going. It has its ups and downs, and there's a lot of work to do there to fix the downs. The ups will take care of themselves, but the downs need working on, and that's what we need a strong office for, strong department to be in office. So in closing, Mr. Speaker, I just wanted to make sure those words were heard, that we got to be very careful here not to do something in this department that'll even downgrade our fishing industry any more than it is. Thank you. And I hope this bill passes through, and I hope it does with the proper amendments to it. Thank you very much.
Thank you. The Honourable, the member for Shelburne.
Thank you. Thank you, Mr. Speaker. It is an honor to rise today and speak on this particular bill, the Public Service Act, the amendments. And like my colleague spoke earlier, my focus was on one sentence dealing with Section 25A. And particularly, it jumped out at me, and I'll just read that particular paragraph or the one sentence. There shall be an office of fisheries in agriculture. And to me, the term, or the key word there is office. And the earlier speaker talks about downgrading. And I want to bring to the members' attention that I hope the emphasis here of amendment is to make something stronger, to make something better. And I believe, and I will not rush to judgment here, but I believe that it is the intent to make this fisheries or this particular office or department better. And I don't like the words downgraded or diluting anything. I think that we have to look at this fisheries and take this very seriously. And I think the key word there that should be included is leadership. Leadership on identifying an industry that has been the backbone of our economy and coastal communities for generations. And leadership will make this a higher priority. Mr. Speaker, the importance of the fisheries, and if I could just take you back to 7 years when the government of the opposite the floor took power, and I clearly remember sitting in at the municipal office, and there was a motion tabled at that time, and there were some concerns about the present government of the day having the Minister of Fisheries holding four portfolios. That was some concern of coming from the Barrington municipality, and they tabled a motion, and they were concerned then about this particular industry having the minister and having the burden of other 3 portfolios. One of the lines that I like to use in Shelburne County that I think captures the whole essence of our industry is that the fishery is the lifeline of our communities. That has been changed or in different terms or different words used. Some communities use the fisheries as the economic engine. Others describe it as the backbone of our economy. Regardless of how you say it, it is the major cog in our industry in coastal communities. Mr. Speaker, I had the privilege of traveling around our province in the last few weeks, and I took particular notice, particularly in fishing communities, in recreational use of our water in our summers, that we see our pleasure crafts being hauled ashore, and they're being ready for winter. They're being winterized. A lot of our fisheries take place in the summer months. And I've had the opportunity to travel from Cape Breton to Barwon in the last few months, and it just struck me that representing Shelburne County, as all these particular fleets and recreational groups, the Northwest Arm, it was literally full of pleasure crafts in Chester Basin this summer. And when you go there now, and we notice the winter, the changing of the weather in this last week, them vessels are being winterized. But in Shelburne County, we are just preparing for the upcoming season, which is the economic engine of our community. So it is vital, and it's very important that the people of Nova Scotia, especially you people sitting in this house, understands the importance of this fisheries. And I invite you all to come down the last Monday in November and see an industry that is taking place, the many suppliers, the trap builders, the boat shops that depends on this industry. And I'll just take you back to 2 minutes ago when most of the recreational use or the commercial fisheries, recreational use in Nova Scotia are being prepared for winter. Shelburne County is just getting started and looking forward to that winter conditions. We also have a great number of high-tech fish buildings or holding facilities, the lobster holding facilities. These have made some economic investments over the last year. And again, the point that I'm trying to make here is that if we have, regardless of the name, whether it's a department, whether it's an office, whatever you want to call it, if the minister is in charge and is going to make these a priority, then I think everyone in the fishery industry, my colleagues, will endorse that. But if this is going to dilute what we already have, there's going to be a clearer message from all these coastal communities. This particular office can also ensure that they can be a stronger voice for some of the bills that we have in front of us today. One of them is Bill 27, the Fisheries Loan Board. That can be speeded up. That can go a long ways in helping young individuals get into the fisheries. That's something that this office can do. We have unemployment workers in Shelburne County that has been waiting for September the 5th for a meeting with the Minister of Human Resources or Minister dealing with unemployment insurance, and they're still waiting. They're still waiting for the phone call to discuss the topic of why a fish plant worker in Shelburne County needs 560 hours, and the same fish plant worker on the other end of our province only needs 420, using the same resources and the same identical fish plants, and they're still waiting for the meeting or the phone call. That's something that this office can do. We've talked about intergenerational transfers of licenses. We talked about establishing a loan board act that we can assist young fishermen to get in the fisheries. This has been discussed for decades, not months, not years, but decades. This is something that this office can improve. And I also want to make note, Mr. Speaker, that our provincial Minister of Fisheries has held fisheries conferences in Nova Scotia for the last decade. This is something that can be strengthened through this particular office. And issues like soft-shell lobsters, we're just crossing our fingers, waiting, and the information is in that the surveys have been done, and there's a good blood count, there's good protein level in our lobsters this year, and we're hoping that we do not have that issue come to surface this particular year. Them is something that needs to be addressed. There has to be a more proactive approach in addressing these fisheries issues, and I suggest that this is something our office needs to do. Mr. Speaker, I want to go on public record. The cod moratorium was established in 1992, and very little has been done, if any. And I want to make it publicly clear that this Atlantic fisheries can be brought back. This Atlantic fisheries can be enhanced. And this is something that the Nova Scotia Office of the Fisheries should do starting today. My colleagues from Pig 2 Weeks, his years of experience in the fishing industry will follow my comments. But there was a comment made by a general automotive dealer a number of years ago, and I think this particular saying fits very well in my closing remarks. When he's talking about the fishery, I think this government should lead, follow, or just simply get out of the way, because our fishery is too important and we need some leadership on these major points. Thank you very much, Mr. Speaker.
The honourable member for. Okay. The honourable member for Pig 2 East.
Mr. Speaker, first I want to begin on a very positive note. I know this is a housekeeping situation that we are looking at here. It's something that was announced quite a while ago, and I believe that the separation of agriculture and fisheries is a great move on the government's part. It was folly in the first place to put those two departments together. These are the departments that feed us as Nova Scotians. These are important departments. Now, having said that, I still want to be positive. I want to say that I respect the two ministers involved with agriculture and fisheries. I think they're good people. I think they are capable. But I thought that the restoration of these departments as individual departments would in fact give them a rightful place in Nova Scotia. And when I look at the legislation and see that there shall be an office of fisheries and aquaculture, the governor and council may appoint a person to be chief executive officer of the office of fisheries and aquaculture. The office of fisheries and aquaculture. You know, these departments cannot be relegated to be junior portfolios. They cannot be relegated to be entry-level portfolios. We have to ensure that these departments do the job that they were designed to do. Now, I want to speak a little bit about some personal knowledge, because after spending a number of years in the voice and print media, I went to work for resource departments as a public relations officer for agriculture, for fisheries, for the old Department of Lands and Forests, and then started to work with fisheries as manager of field services, as aquaculture administrator, as marine advisor. So I have a bit of knowledge about the history of these departments, and I look back on the old departments of agriculture and fisheries in the 1970s and 1980s as departments with guts, departments that stood on issues, departments that were in there with Ottawa all the time. And we have had an erosion of that. It doesn't exist anymore. We can take a real lesson from our sisters and brothers in Newfoundland. When they go to Ottawa, they go to Ottawa with kathump. There is no whimpery. There is complete kathump with what they're doing. And I think we have to get back to a very, very aggressive situation here. I mean, we have a minority government with a majority cabinet. I think almost everyone is in cabinet, so you take out the, the deputy House leader and so on. I think almost everybody is in cabinet except 2 or 3 backbenchers. So there should be an opportunity when a person has a single portfolio to really do something for Nova Scotia. And that is what we expect to take place. I think we can also learn from Newfoundland in the aggressiveness that is shown with Ottawa. And I believe that every dollar in Ottawa should have at least some little percentage on it for Nova Scotia. I firmly believe that. And I think it's up to these ministers to go after the CASE program in agriculture and to go after fisheries, to wrestle a little bit more power and have some more input in relationship to these departments. On Sunday night last, we had a forum in Pictou East. It was a forum that I organized, and I had 3 critics besides myself. We had 4 critic areas represented in a forum. And a director of the cattle producers of Pictou County attended the meeting and asked some real pointed questions, like, where is agriculture on the political landscape in Nova Scotia? And there was a feeling there, demonstrated from that farming interest, that since there's only 2% of people in Nova Scotia, somewhere around 2% that are involved in some form of agriculture, that there isn't the relevancy that there used to be. And if we're going to keep our schools open in rural areas, if we're going to have vibrant rural communities, we need those farmers, and we need to be fighting in Ottawa for them. I think that some of the responses given in that form were some of the most emotional responses that I have heard for a long time. And the critic for agriculture, the member from Hants East, was very, very compassionate and very passionate in his responses to the agriculture questions. So I believe that that's what we fundamentally need is that kind of a passion. And you know, I would hope that the passion that is shown on so many issues on this side of the House would sort of seep over into the government side, at least until we get there. So, what I'm asking, Mr. Speaker, what I'm asking is that the minister is, now that this separation has taken place, that we take the most aggressive stance that we have taken on agriculture and fisheries for many, many years. And I hope the transformation, you know, I'm not asking for a road to Damascus experience or a road to Muscadabat or a road to Canso experience, but I think there has to be that kind of a transformation that takes place in agriculture and fisheries. And I strongly disagree with this business of office of fisheries and aquaculture. I can see our people involved in various forms saying, after Newfoundland representatives indicate that they are from the Department of Fisheries, and our people saying, I'm from the Office of Fisheries and Aquaculture. An office to me seems to be a smaller scale. The office of. Please, please, if there's any way of changing this to department and giving some real status to the division that's taking place, I hope that it does, in fact, come about. So, with those few remarks, I want to conclude, I guess, by saying at one time these departments had salary levels down here and programs up here. And I think over the years we've had a situation where we now have sort of salaries up here and programs down somewhere. And I think we have to get back to the days of the 70s and 80s when there was a real emphasis in these two departments on various programs, from the school milk program through to a host of fishery programs. So with that, I will conclude. Thank you.
The honourable member from Halifax, Clayton Park.
Thank you very much, Mr. Speaker. And I wanted to address just a couple of points around Bill 14 that haven't been talked about today as much. We've had a good discussion, I think a lot of thoughts on the fisheries and aquaculture. But I'm looking specifically at the portion of this bill which will officially repeal the Petroleum Directorate and instead replace it with the Department of Energy. which again obviously is a bit of housekeeping because we've had a Department of Energy for quite some time, certainly as long as I've been elected here in the legislature. The Petroleum Directorate was originally founded, I think, under the Department of Economic Development, and it had a very clear purpose. As I understand it, it was that we needed to get expertise in the offshore energy and get a core of people together who could do the negotiations and the work that the province needed to do in order to get our offshore energy moving better and being able to negotiate with all the international firms and big companies that would be here. And that folded in over time into a new Department of Energy. And what I'm finding as of today, and even looking at what this Department of Energy is going to be responsible for, I still find some I would say that there's been some blurring of what that department is all about. And it is not my area that I am critic for, but I am very interested in Conserve Nova Scotia. I'm very interested in environmental policies and plans. And I'm interested in how the Energy Department has played a role and perhaps continues to play a role in those programs. And I draw your attention, Mr. Speaker, to Section 4 of this Act, which talks specifically about the Department of Energy and outlines what exactly they're supposed to do, and it has from A to G that they're looking at. Now, the ones that I would say were more like the original Petroleum Directorate have to do with conducting research and analysis to effectively manage the offshore exploration. It says exploration and development of the province's energy resources. And D, which says managing the province's energy resources in order to achieve optimum economic and social environmental value. I think that would have been consistent with the original Petroleum Directorate. But the part that I think is a little unclear, and I'm surprised that it still appears in this Act today, when we're at, we've already announced a Conserve Nova Scotia, and we already have a person appointed to be CEO of a very well-paying position, I might add, to manage and direct that new Conserve Nova Scotia. But we still have the Energy Department on E, under all of their activities, promoting the efficient, effective, and environmentally sound use of energy. And surely that would come under, it's not under exploration, it's not under maximizing the resources or the revenue that we'll receive, the royalties and so on that we would receive from promoting all of the energy resources in Nova Scotia. So I wonder why that environmentally sound use of energy, the conservation side, is still nestled within the department's proposed, it's more than proposed, it's in the bill, in what will be seen as their mandate. And I think that we've got a real blurring, and if Nova Scotians were to look at where would they find information on conservation, and remember, conservation goes a lot beyond energy, it would be a one-stop shop, a place that had all of the environmentally sound practices, whether it had to do with solid waste or with energy use or any number of other practices that Nova Scotians would want to know about in order to be more environmentally sustainable. I would think they might look to the Environment Department, or they will now look to Conserve Nova Scotia. So I think it's a little bit inappropriate that they still maintain within the mandate of this newly defined, shall we say, Department of Energy, that it would be promoting the efficient, effective, and environmentally sound use of energy. I could see them promoting the environmentally sound development of energy or practices of the energy industry, but I just question why we continue to have this blurring, I think, in the minds of Nova Scotians, and rightly so, with the announcement of a brand new department or a brand new agency. We know as well that 10 of the employees from, I believe it's 10, from the Department of Energy have now been transferred or are in the process of being transferred to the new Conserve Nova Scotia. So they're going to form the core of the expertise that will run this new agency. If they're leaving the Department of Energy, are we duplicating their services again? Are they going to continue to be replaced at the Department of Energy? Or has that core of expertise in the government moved now to Conserve Nova Scotia? And so the reason I raise this is I think there's a question around having too many different agencies or departments with an overlapping mandate. And I think we saw it last year, even when the Department of Energy was handing out the, along with the Keep the Heat monies, they handed out little packages of things that you would use in your home to help conserve energy, everything from water reduction to weather stripping and energy efficient light bulbs, all of that coming from the Department of Energy. Well, surely in future, anything like that, any program like that would be directed from Conserve Nova Scotia. So I think it's really worthwhile for the department to perhaps reevaluate that, perhaps for the government to reevaluate that one activity and provide clarity for Nova Scotians about exactly where we want the expertise in our civil service to rest and where Nova Scotians can go to get answers in one place within the government on environment and the careful use of energy. So that's a point that I think should be raised and considered by all members of the House. Beyond that, I think we've covered aquaculture and fisheries very well, and I see that we've also included information on the Department of Health Promotion and Protection, which is the new name, and I would say a very clear mandate for what that department is now going to do. And again, certainly our caucus has applauded, first of all, the forming of an Office of Health Promotion and its increased strength as it has grown over the last few years to encompass quite a few areas. I think, in fact, it's quite all-inclusive around the area of health promotion and now health protection. So we do applaud that because we've always said that we needed to take a long-term view of population health. So with that, Mr. Speaker, I thank you very much, and I'll take my seat.
The honourable member for Queens.
Thank you, Mr. Speaker, and thank you for giving me the opportunity to speak to this bill to amend the Public Service Act. I want to give kudos to the government for recognizing some time ago to actually create the Department of Health Promotion and Protection. I think it was a very smart move, and with the growing portfolio of the Department of Health, certainly health promotion and protection needed to be in its own host. I want to speak specifically to the clause adding provisions respecting the Department of Health Promotion and Protection. And while the mandate looks very clear and certainly covers a lot of ground, I'm certainly hopeful that the department does not become a standalone department and looks at the need to really cooperate and to show leadership with other departments of government. And I just want to draw attention why I am bringing up that important need to show leadership from this department is in the clause 46C. The language says, in addition to any powers given to the Minister of Health Promotion and Protection by an enactment or the Governor in Council, the Minister may. The word may is not a very strong word, and I would suggest that in order for the department to show true leadership in cooperating with other departments, that that language should be stronger. Perhaps to the minister will show that leadership. I want to speak about the promotion of healthy eating and the promotion of healthy foods in our province. And while the minister and its department has taken great strides in promoting healthy food initiatives in our schools across the province, I'm hoping that the department and the minister also acknowledge and recognize that too many of our Nova Scotian families do not have the financial resources to eat healthy. And so again, I'm going to take us back to the need to cooperate and show leadership with other departments, and I think the department really needs to network and advocate with other departments such as community services in ensuring that families living in poverty actually are included when we are talking about healthy eating and healthy promotion. We need to really ensure that these families have the financial resources to go out and buy healthy food products. I'd also like to say, too, that the department needs to recognize and should be working with the Department of Aquaculture, Agriculture and Fisheries when we're talking about healthy food products. We need to be promoting our natural food resources that come out of our agricultural and fishery industries. And so when we're talking about healthy food products and healthy food promotion, we need to be talking about healthy products grown in the valley and fished off of our coastal waters. And we need to protect those food resources. And of course, the Health Promotion and Protection Department looks at the protection of all of Nova Scotians. And so it's very important that we have a lot of good protection policies around those natural food resources. I'd like to talk a little bit about increasing the physical activity with Nova Scotian families, and we have seen the department demonstrate a lot of good initiatives across the province, and in particular the walking initiatives. But I think we need to go, a few steps further, and that's promoting sports and recreation, and more importantly, too, looking at those families and children who can't afford to participate in some of the sports around the province and or don't have access to recreational facilities. So I'm hoping that the department really shows true leadership and invests dollars in recreational facilities across the province, and also give incentives to low-income families to allow their children to participate in sports, and really promote the physical activities of Nova Scotians. We have an alarming rate of growing numbers of childhood obesity and children who are being diagnosed for type 2 diabetes. So it's really important that we do not drop the ball on health promotion and physical activities within the province here. And again, cooperating with other departments to make sure that happens, working closely with the Department of Education is most important. The Department of Health Promotion and Protection has a huge responsibility for the health protection of Nova Scotians, and we really need to be front and center and show true leadership, and I'm hoping that this department really recognizes the serious responsibility of the protection for Nova Scotians. And we have a growing number of communicable disease concerns facing us in this province, and I want to just talk a little bit about those. We're all aware that Lyme disease is a growing concern in our province, and certainly the deer tick population has been increasing for a number of years. And that's a serious concern, and it is a big responsibility for this department to really make sure that they're watching the growth of this deer tick population very closely, that they have a good monitoring system in place, and that they're just not relying on people in communities to be bringing in ticks for examination, that they're also doing their own monitoring, that they're getting staff out there and they're recording numbers, they're looking at geographical patterns of where the deer tick is moving, and also making sure that we do have accurate stats on that. The deer tick population, interestingly enough, not only is it increasing, but our tick population is staying in great numbers in Nova Scotia. We no longer have the cold freeze winters to stagnate the tick population, and so we really need to recognize that climate change plays a big role in the movement of deer tick populations. And when we speak about climate change too, I also want to bring to the attention of the Department of Health Promotion and Protection the increase of asthma across the province. And we do have to really keep our eye on the growing numbers of children who are experiencing respiratory illnesses at younger ages. Many of our young children are walking around with 1 or 2 puffers in their backpacks. They're needing to rely on these puffers for daily breathing, and we really need to keep our eye on the growth in asthmatic and respiratory illnesses across the province. And again, I'm going to go back to working closely with other departments. I think it's important for the Department of Health Promotion and Protection to work closely with the Department of Energy in terms of getting a handle on our reduction in our pollutants. which is a leading cause of asthmatic and other respiratory illnesses. So it's important that while the Department of Health Promotion and Protection has this huge responsibility, I think they can share that responsibility by networking closely with other departments, really looking at other sources of clean, renewable energies that could certainly play a big role in reducing some of our respiratory illnesses. And we really need to take the issue of climate change very seriously, because that in itself is going to also lend to an increase in numbers in not only respiratory illnesses but other viruses that we're going to see coming our way. We need to be prepared for different types of viruses, whether we're talking about avian flus, other communicable diseases that we may not be aware of, and we do need to be prepared. In conclusion, I do want to say that while I support this bill and I support the Department of Health Promotion and Protection, I'd like to see the department really take its responsibilities seriously, really network and show leadership with other departments in government. Thank you.
I'll recognize the honourable member for Annapolis.
I've been inspired by the member from Queens to stand and say a few words regarding health promotion, and I'm always that's right. And the issue has been coming in my riding is around the issue of health promotion and providing it to our children. And we've talked about a healthy foods policy in this House, Mr. Speaker, in particularly with the Department of Education. And I think it's interesting as we've developed a Department of Health Promotion, what role they played in that healthy foods policy that the Department of Education is now putting on to school boards across this province. It's rather interesting. We spend so much time talking about 5 meals out of a 21-meal cycle for our children, when if we're really talking about health and health promotion, the real challenge that the new minister or the Minister of Health Promotion should be saying to the Minister of Education, no, we should be instituting physical education on a daily basis in our schools. If that's what we're talking about is the health of our children. How can we improve the quality of life for our children and their health? It would be very simple, Mr. Speaker, and that would be to institute a daily physical education program, not for senior high, but start at primary and go right through to grade 12, Mr. Speaker. It's been interesting as this food policy starts to develop and we see it coming across, and we're focusing on that as a big initiative to improve the health of our children. We're also starting to find now that it's become a real challenge for organizations within our school system, BAND, which is providing an opportunity for the health, the social well-being of our children to continue to sustain themselves. The department in its infinite wisdom is suggesting that apple pie is no longer healthy. It's no longer something that we should be selling as a school to raise money to ensure that our children are exposed to this kind of quality of education. Somewhere along the way, someone said, it's not healthy. Why are we doing that? They've actually come out to schools in the Valley, of all places, the apple capital of Nova Scotia and Canada, of course, the world, and said, unfortunately, the apple pies that your grandmother made, the apple pies that you're making are not healthy. But we'll send you down to some prefab pie, and perhaps we can sell those. And you know, Mr. Speaker, what's rather interesting about that is a $10,000 fundraiser for one school in my riding. That's for one. And nowhere have they said, you know what, how are we going to fund that program? Where's the money coming from? We're talking about healthy food for our children. This policy has become so bizarre that the BAND program cannot sell it to the community. People who don't even have children in the school. The school cannot make that apple pie and sell it to the community because it doesn't fit within the parameters of this food policy. And you know, as a parent with 2 children going to that school, we have looked at this healthy food policy, and we've said to ourselves, if the school is concerned, if the Department of Education is concerned about our children's health, why don't they say to us, we're prepared to institute physical education on a daily basis for those children, and we'll let you worry about what they're going to eat. But instead, what does the department do? They focus on the thing that I think they have the least impact on. they have the least impact on. Most of those kids perhaps eat 1 or 2 meals a week at that school. The rest of them come from home that their parents have prepared for them to bring to the school. If it's about health, if it's promoting a healthy lifestyle, then they should be instituting that physical education. And I look forward to the minister standing in this House and saying to all of us, to the day that physical education will be mandatory from grade primary to grade 12. And then I will stand up and say to them for the first time that they move forward in trying to protect the health of our children. So, Mr. Speaker, I want to close on that, and I look forward as this moves into law amendments and people come forward to have a chance to speak on it.
Further members? I'll recognize the Honourable Minister of Service, Nova Scotia and Municipal Relations to close debate.
Thank you, Speaker. And just in closing debate on Bill 14, I want to acknowledge the supportive comments that came from both parties on the other side of the House. I think everybody recognizes that, particularly with the separation of the fisheries, aquaculture, and agriculture, recognizes the commitment of this government to the resource-based industries in this province. I think as well the member who raised the issue of the Department of Health Promotion recognizes that changing that from an office to a department, we were the first government in Canada to have one of those at the provincial level, and it is a very important part of the go forward in terms of healthy Nova Scotia by this government. And in response to the member from Annapolis who just spoke about phys ed, I would remind you that in the platform there is a very specific statement about an increase in the time for physical education, and that will come too. I would also think that the energy plays an important part in our province now in many ways, one economically in terms of the offshore, also in our effort to conserve energy, and of course the issue of many things along with the Department of Environment. The issue of global warming is very much in the papers at this time, and how we can conserve energy and do our part to be Canadian and then world leaders in protecting the environment, and obviously conserve Nova Scotia, which is under the Department of Energy, is going to play a very, very important role in that, and I look forward to the results of that first year in office. Mr. Speaker, again, I want to thank colleagues from across the House for their helpful and their supportive suggestions. Their comments indicate that the government clearly has gone in the right direction with this bill in separating agriculture and fisheries and creating the offices or the Departments of Health Promotion and Protection and the Department of Energy. And I now close debate and move this bill on to law amendments. Thank you.
Thank you. The motion before the House is for a second reading on Bill number 14. All those in favor of the motion, please say aye. Those against, motion carried.
Bill 14, entitled An Act to Amend Chapter 376 of the Revised Statutes 1989, the Public Service Act.
Or that this bill be referred to the Committee on Law Amendments. The Honourable the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, would you call Bill 22, Motor Vehicle Act, for second reading?
Bill number 22 for second reading. The Honourable the Minister of Transportation and Public Works.
Thank you very much, Mr. Speaker. I move that this bill be now read a second time. Mr. Speaker, the bill before us is one which reflects the changing nature of technology and methods of employing equipment in order to carry out the functions of agriculture. And as a result of changed equipment, then it's appropriate that we need to have new definitions. We need to change items related to the use of cautionary signs and speed limits, the combination of vehicles that require brakes and do not require brakes in certain circumstances. And that is what the bill is intended to do, Mr. Speaker. The department worked very closely with the Nova Scotia Federation of Agriculture in developing this bill over the period of the past 2 years, and the changes that are proposed in the bill reflect the thinking collectively of the Federation of Agriculture and the departmental officials charged with the responsibility of developing this legislation. And I can say, Mr. Speaker, that some of the changes that we will be looking at are found in sections 2, sections 117, and sections 181 of Chapter 293 of the Motor Vehicle Act. And as I indicated, they include new definitions and speed limits and new requirements for brakes. There is a change in definition of farm tractor. It is being changed to allow some loading, but not to the extent that farm trucks would be classed as tractors or farm tractors. Modern farm tractors come equipped with attachments such as front-end loaders and small spreaders with limited carrying capacity to make the tractor more versatile and efficient, and the proposed amendments allow such loading to occur. An implement of husbandry is being expanded to vehicles, both self-propelled and towed, used in farm operations, for which the new rules would apply. This housekeeping amendment would add clarity to the Motor Vehicle Act. And farm wagon is a new definition for a common farm vehicle. With respect to the movement of vehicles, new restrictions concern the maximum speed for vehicles displaying a sign or a cautionary sign. Currently, there is no maximum speed limit for a vehicle displaying a slow-moving sign. The new 40-kilometer-an-hour speed limit will also apply to operators of backhoes and loaders. This change is to ensure the safety of the farm community and the traveling public who expect vehicles displaying a slow-moving sign to be moving slowly. The new legislation requires that no brakes are on towed farm vehicles provided a slow-moving sign is displayed on and the above rules are followed. So, Mr. Speaker, I'm very pleased to present this bill to the House, and will listen intently to comments from members with respect to the bill, and look forward to its passage and moving on to law amendments. Thank you, Mr. Speaker.
Thank you. The honourable member for Henseys.
Thank you, Mr. Speaker. I want to thank the minister for his comments. I guess at first blush, my thought is there's nothing wrong with this at all. I mean, I'm thinking it should make perfect sense, and the fact that